Good evening. A very warm welcome, colleagues and friends, on this glorious Melbourne evening. We are deeply appreciative that you have braved the wind and the rain, the hail, the occasional dash of sunshine to be here this evening and join us for this very special occasion. For those that don't know me, my name is Sharon Pickering. I'm the Vice-Chancellor and President of Monash University, and it is a real privilege to be invited here this evening. I would like to begin by acknowledging that we are on the unceded lands of the people of the Kulin Nations, and I pay my respects to Elders past and present, and I particularly extend my respects to Indigenous colleagues gathered here in the room for us this evening. I, of course, wish to recall and acknowledge that this has been a place of great learning for many thousands of years. I would also like to acknowledge our host this evening and Chair, Ms Fiona McLeay, Victorian Legal Services Board CEO and Commissioner. Our speaker this evening, Professor Steven Vaughan, Dean of the Monash Faculty of Law, and Steven's husband, Dr Digby York. I'd like to acknowledge the Chief Justice here and honourable members of the Judiciary, distinguished guests, colleagues, one and all. I am deeply appreciative for you joining us here for what is, in essence, the revival of Monash Law's professional lectures. They are an important opportunity to further enhance the law faculty's engagement with the legal profession, an engagement that runs deep, an engagement that is treasured. And importantly, an opportunity to share the research and expertise of the faculty with the wider community. It's a wonderful occasion, not yet, or maybe just 6 months on, just squeaked 6 months on, to again publicly congratulate our Dean of Law, Professor Steven Vaughan, on his appointment as Dean and for restarting these wonderful events. I'm delighted that you've done this and you've backed up your decision by volunteering to do the first one. So, well done. But of course, you join a distinguished list, a number of colleagues who are here in the room. Monash University's Francine McNiff, Chair of Jurisprudence, Liz Campbell, Jonathan Clough, also Professor John Coffey have delivered these lectures previously. I think it's nearly a year to the day that I sat in a restaurant in London. We had interviewed Steven a week or so before. No, actually a week before. I kind of almost chased you back to the UK. When Monash is committed, we're really committed. And what had become apparent to me and apparent to the university panel was that we did indeed have here our next Dean of Law, and my job was to make sure we got the job done and we got him across the line. Steven joined us, as many of you are aware, from University College London. University College London is a very happy recruiting ground for Monash University. It's an institution which we share a number of attributes, nature and shape with. And of course, that's where Steven was Professor of Law and Professional Ethics. What was abundantly clear to me and to my colleagues at that time was that here we had a values-driven leader, someone who wasn't simply committed to equity, diversity, inclusion, but knew how to live it without ever stepping away from excellence. And indeed, we had someone here who has dedicated so much of his career to developing teaching approaches that influence, that motivate, and that inspire our students to learn. Of course, we knew that he would be a wonderful Monash Dean of Law because of his very genuine and great belief in the value of clinical legal education and the power of law through clinical legal education to transform society. So we really did feel we had a perfect fit for this faculty. Because of course Monash Law, as so many of you have known and so many of you have contributed to, from its very beginning was intended to be a place of innovation, to be a different kind of law school. And our first Dean, Professor David Derham, ensured that Monash Law was indeed a place where theory and practice were closely aligned, with curriculum designed to reveal the functions of law in society. As early as 1971, our law students had opened a volunteer legal referral service, while other students and staff were assisting in the development of the Springvale Legal Service. Just a few years later, in 1975, Monash Law formalised its association with the Springvale Legal Service by introducing the Clinical Legal Education Program, which of course is now delivered through the Monash Law Clinics. And Monash would become the first law school in Australia to embed clinical legal education. And this year, that means we're able to celebrate its 50th anniversary as a clinical legal education program. A program that is now the largest provider of access to justice by supervised legal clinics in Victoria, supporting almost 7,000 Victorians in the past 5 years. And these clinics do, of course, serve the most vulnerable, the most marginalised, the most financially stressed members of our community. Those who can't afford a lawyer, who don't qualify for the limited publicly funded legal aid that we have. That clinical program has inspired further programs. The Street Law program that provides free community legal education workshops in the community, and late last year the extension of this in the launch of the Justice Bus that takes the program to regional schools and young people around Victoria. Our commitment in Monash Law and across the broader university to public benefit, I think, is exemplified by the deep engagement of law academics from this great faculty in the social impact of law. And I just want to call out here tonight the excellent work that Professor Ronley Sifris and Becky Battergall are undertaking with the Australian Law Reform Commission and their the recent report, Safe, Informed, Supported, Reforming Justice Responses to Sexual Violence, which is what Becky contributed to, and the work of Romley in working with another great Monash alum and the Commission's President, Justice Morty Bromberg, in the Australian Law Reforms Commission review into Australian surrogacy laws. Monash Law, in so many ways, is the absolute embodiment of Monash's founding purpose: to achieve generational social and technological transformation, to meet the challenges of the age, and to do so for the aspiring communities and industries around us. It is now my great pleasure to introduce our host tonight, Ms Fiona McClay. Fiona has, since 2018, held the dual role of Victorian Legal Services Commissioner and CEO of the Victorian Legal Services Board. She's co-chair of Equality Australia and chair of the Australian Communities Foundation, and has previously served as board chair of Health Justice Australia, deputy chair on the advisory board of the Australian Not-for-Profit and Charities Commission, and on the board of the Human Rights Centre. Her own legal background spans private practice in the not-for-profit sector. She was formerly CEO at Justice Connect, a leading not-for-profit that provides free legal assistance to both individuals and organisations, leveraging the pro bono skills of the private legal profession. Somehow, in amongst that career, she's also held executive roles at World Vision Australia, and of course has practiced law for several years, including as special counsel at Clayton Utz. Please join me in welcoming Fiona this evening. Thank you.
Thank you for that introduction and that welcome. It's terrific to be here on Wurundjeri country. We are in wombat season, although I think any self-respecting wombat would be firmly in his burrow tonight. I had lunch with Stephen and Digby 3 or 4 weeks ago, I think, on a balmy early winter's day in the Botanic Gardens. It was about 19 degrees and sunny, and one of them said to me, "So is this what winter's like?" And I said, no. So just for the record, this is winter. Yes, it won't last for long, but we do have winter. It's an absolute honour to be asked to introduce the new Dean of Monash University Law School to give this professorial lecture. Steven is new-ish. He started at the beginning of the year. My colleagues and I at the Board and Commissioner have had the delight of meeting with him several times already and really benefited from both his expertise and the way that he delivers that expertise, which you will soon experience yourself. I met Steven quite a few years ago at the Nerdfest, which is the International Conference of Legal Regulators, and then again at the Nerdfest, which is the International Legal Ethics Conference, and we connected immediately, and I was beyond delighted when he let me know that he was coming to Monash, not just because he's a wonderful human, but also imagine, from the legal regulator's perspective, having an ethicist heading a law school. It's a dream come true. So, as you will know, he comes to us from Great Britain, where he had a distinguished career at University College London and universities in England and Wales. He's got a very eclectic set of specialties: environmental law, lawyers' ethics, legal education, diversity and corporate governance. Part of the reason for that eclecticism is because he spent 10 years in practice with corporate law firms in London, with a particular focus, believe it or not, on the chemical industry. He's got a very interesting story about what led to that sudden change of direction. That may or may not be in the speech tonight. If it's not, you can ask him over drinks. Like Steven, he's not the first lawyer to broaden out their career after developing skills at the big end of town. As you've heard, I am also one of those. He's been a really strong contributor to the legal profession more generally, and in the UK he has had a number of non-executive positions in a range of bodies, including as chair of the Joint Academic Stage Board, which is a very strange title but really just validates qualifying law degrees across England and Wales, and so is very important notwithstanding its title. He's got a strong commitment to professional ethics, which, as I've said, is really of great interest to me as the regulator. He's co-authored a book with Professor Richard Moorhead on legal professional ethics and in-house lawyers, which is something which is a focus for my team and I in the wake of things like the robo-debt and Crown Casino Royal Commissions and what's known as the Post Office scandal in the UK. So Steven's lecture this evening poses an existential question about lawyers. What's the point of lawyers? I don't mind saying that as a regulator I occasionally ask myself the same question. So Steven's question could take us in a number of directions. I won't be reflecting on that part of it any further, but I think we may ask ourselves a follow-up question: what's the point of legal regulation, which I think must flow from pondering Steven's question. For us as the regulator, we want to ensure that the paramount duty to the court and the administration of justice is kept firmly in view for all practitioners, and to help lawyers work through what that actually means in their day-to-day practice. Lawyers occasionally get some bad press, and some of the causes of the negative perceptions of lawyers are often beyond our control, and certainly as the regulator beyond our control. Litigation doesn't deliver the results that were anticipated or hoped for. Many people are unable to afford a lawyer if they don't qualify for legal aid, or they can't find a lawyer whose skill set and approach matches the need that they have. Unfairness can spring from an act of parliament and the application of a law to someone that that person is opposed to. The systems we put in place, the way the insurance regime works, indeed the complaints and disciplinary process that I administrate, can ameliorate some people's negative perceptions of the profession, but sometimes reinforce them. There are, though, some lawyers' actions that polish the community's perception of the profession. Lawyers that provide skillful, independent and wise advice to clients who are pleased to acknowledge the valuable assistance they've received. lawyers who work for the marginalised and disadvantaged, including by providing significant amounts of pro bono work. It's occasionally interesting for me to ponder that I spent the first part of my career focused on lawyers being their best selves, and a lot of my time now focusing on lawyers who are not. Lawyers also, of course, work to challenge unfair laws and to change those, whether it's through policy and advocacy work or in court victories that are widely acknowledged and celebrated, such as Mabo and some of the work that our Chief Justice, who's in the front row, did before he went to the bench. And yet, despite all of this, should we expect more of our lawyers? Many lawyers are confident that they practice in an ethical way, and many of them do if you look at the rules, but there's not as much of an understanding as I would like to see of the underlying principles that support that conduct, relying instead on gut instinct and previous experience. Mentioning ethics, CPD in polite company, which for my sins I occasionally need to do, is an invitation to exasperated groans and complaints from lawyers about how hard it is to find good quality training and how to get the magical ethics point, which for reasons that I've never been able to understand, people find difficult to find. Surveys, including ones conducted by Steven and his colleagues of UK in-house lawyers, show a lack of awareness of this paramount duty to the court and to justice, and a lack of its consideration in daily practice. So it begs the question, what is a lawyer's responsibility to provide advice that goes beyond technical legal competence? We know that clients value advice that's grounded in the wider circumstances of their position and addresses the wider issues of risk that they face. But should ethical or moral judgments be part of the wider spectrum of advice provided, and in what circumstances? When should a lawyer include advice about what someone should do as well as what they can do? And is a lawyer's cherished independence a suitable platform for a wise counsellor, or does a delivery of more widely framed advice risk undermining their role? As I talk to lawyers, there is a real desire for them to be connected to this deeper part of their work. Talking to them about the importance of the role that they play in upholding the rule of law resonates strongly with lawyers. And yet there is, I think, some questions and some greyness about what that looks like in practice. In my role as the regulator, we try very hard to promote the administration of justice in the rule of law. Indeed, that's our kind of reason for being, and is encapsulated in our strategic objectives of protecting and empowering consumers, improving legal practice and ethics, and improving access to justice. We constantly ask ourselves how best we can improve our support for ethical practice, what are the issues of concern, the breaches of existing rules, advice and actions that are not within the spirit of the law as well as within the letter of the law. Oppressive use of available remedies, similar to the concerns that led us to provide guidance on non-disclosure agreements, for example, and our work on the obligations of in-house and government lawyers, which we currently have underway. The Legal Services Board in England and Wales is doing similar work and is more advanced than we are, and Steven's former colleagues at UCL have made substantial contributions to that work. It's a really important project at a time when many of the institutions in democratic societies, including the courts, are being challenged, if not under actual threat. And the role of artificial intelligence in the legal process is a growing challenge to the way that we understand lawyers and their role. We take the rule of law and the associated privileges that lawyers enjoy to exclusively practice their craft as a given. But we shouldn't forget that this licence exists only so long as it is perceived to be in the public interest. Ethical practice and a willingness to actively engage with the paramount duty to the court and the administration of justice makes our defence of the rule of law, the courts and lawyers an easier task. So having posed those questions, I'm delighted to hand over to Steven, which will give us, he'll give us a greater understanding. Will you please welcome Professor Vaughan.
Good evening. My great thanks to the Vice-Chancellor and to the Commissioner for their kind words, to my colleagues in the faculty who have helped to make this evening happen. It is a joy, a real joy to see so many of you here. Who knew that 37 minutes of back-to-back lawyer jokes would pull in such a crowd? Let me also begin by acknowledging that we meet on the unceded lands of the people of the Kulin Nations. I too pay my respects to elders past and present and extend those respects to our First Nations guests. Let me start my lecture by telling you a personal story, partly because law and narrative go together, and partly because, like many academics and many deans, I enjoy talking about myself. My sister Paula and I were the first in our family to go to university. I was finding it hard to decide what to study, French, law, or maths. Double degrees weren't things back then. What helped in funneling me towards law was a television show in the UK called This Life. That 1990s TV series left an indelible mark. It showed the messy personal and professional lives of 5 young lawyers sharing a house in central London. It showed lawyerly conflicts of interest, divided loyalties, lawyers winning at all costs. It showed complex relationships with clients. There was emotion and sex and drugs. When I see my first years, I say to them every year, did television play any part in why you decided to study law? Lots of them say yes. And then I say, which television shows shaped your thinking? And then I show them this slide. Many of them every year nod their heads. They tell me that Suits and How to Get Away with Murder are part of the narratives of why they chose to study law at university. Sadly, very few mention Fisk, which I think is a real shame. There is a lot to be said for a nice brown suit. Why tell you this? Why begin tonight by telling you that I chose law at university over maths and French because of TV? Why tell you that repeated cohorts of our first years say they've chosen law in part because of Suits and How to Get Away with Murder? It is because our social imagination of lawyers is seeded early. What we and our students absorb from those TV shows, what the public sees, is a kind of operatic performance of moral flexibility. Lying, cheating, greed, manipulation, dishonesty, snobbery, and that blurred line between personal and professional lives. Maybe also some complex messaging that if you're very lucky, you might end up as the Duchess of Sussex. That is amusing, but it's also telling. The TV lawyer is often someone clever and driven, for sure, but also untrustworthy, morally compromised, transactional. And that sits uneasily next to what many of us, myself included, think lawyers should stand for. In November 2024, the latest Ipsos Veracity Index showed how nurses continue to be the most trusted profession in the UK. 94% of Britons say they trust nurses to tell the truth. Engineers second, 90% doctors in third. I note professors and teachers are joint fifth. There is no separate category for deans, probably up the top, I'm guessing. Only 55% of the public in the UK expects lawyers to tell the truth. That is not great, but it is better than in other places. Globally, the data from Ipsos says that trust in lawyers is at 33%, and in Australia, 28%. So we tell jokes about lawyers, we roll our eyes at their fees, we worry about their honesty and their motives. Those instincts come from somewhere deeper than TV caricature. So what is going on? Why is it that we as society have such a complex relationship with lawyers? Let me offer a set of interconnected reasons. First, the image problem for lawyers is not just a side effect of television. Stereotypes about lawyers have some purchase because sometimes they reinforce reality. Lawyers can and do appear to act in ways that are clever rather than principled, tactical rather than just. We lawyers can be seen as hired guns who get people off on technicalities, who help the powerful dodge accountability, who argue one thing in court and another outside. Sometimes we are involved in very public scandals. Let's consider lawyer X. Many of you will be familiar with this. Over 15 years, Victoria Police used criminal barrister Nicola Gobbo as a secret informant against her own clients. She represented high-profile figures in Melbourne's criminal underworld, Carl Williams, Tony Mockbell and others. At the same time, she was informing on her clients. The High Court later called this conduct, quote, fundamental and appalling breaches of Gobbo's obligations. A Royal Commission found that more than 1,000 convictions might be unsafe. Several have since been overturned. At the heart of this Lawyer X scandal is the collapse of two foundational legal principles: a duty of confidentiality, a right to a fair trial. These are not minor breaches. They strike at the very basis of trust in the profession and in the system. Lawyers also have a branding issue because of their fees and because of legal needs. And my EA and I had a funny back and forth where I explained this was a fat cat. Maybe I thought this was more obvious than I thought it was. Lawyers do make money. Legal services can be expensive. There are limited legal services offered pro bono. For many clients, the cost of engaging a lawyer is prohibitive. Lawyers can be expensive. Some of them make lots of money for their lawyering. The law promises equality before it, but many people feel and are, in fact, priced out of justice. In Victoria, the 2023 Public Understanding of Law Survey, led by Nigel Balmer and his colleagues, found that 42% of respondents had legal problems. That is 6.4 million legal problems across the adult population. At the same time, the Pulse survey found that where there were legal needs, 78% went unmet. When it's available, legal aid is overstretched. Lawyers who work in community legal centres do extraordinary work under pressure, including my many colleagues here tonight in Monash Law clinics, as do those working for organisations like Justice Connect, but they are simply layers of Band-Aid on a hemorrhage. The justice system is supposed to be blind, but too often it is pay for play. Here, Christine Parker has reminded us that economic strength can have a destabilising effect on the integrity of the justice system. The wealthier party can afford more time, better advice, more experienced counsel. And while that's not always decisive, and while it doesn't always speak to bias, it undermines the sense that the system is fair and that its players, the lawyers, operate fairly or give life to justice. The work and the worlds of lawyers can also be arcane and alienating. Nemo, dat, quod, non habet, and all of that. Giggles from the older educated and the lawyers in the audience there. Instead of empowering people, sometimes the language of law can disempower them. It can reinforce the idea that law is something done to people, not something for people. That lawyers are gatekeepers of a code that ordinary people will just never decipher. We sometimes wear wigs and gowns. I remember going to dinner at the Inns of Court in London, where you'd have to handwrite a note to the top table to ask permission to use the toilet. Lady Hale, in this context, speaks of lawyers who move from quadrangle to quadrangle to quadrangle. If the legal profession has been such a cloistered club, and still is in some parts, is it that much of a wonder that the public can struggle to articulate the place of lawyers in society? We come now to a thornier point. People often dislike lawyers not because what they're doing is illegal, but because what they're doing is legal, but the public perceives it as wrong or unjust. There is that classic dinner party question: how can you defend an alleged rapist? There are other, broader questions about lawyering that could or should make us uncomfortable. I'll now tell another personal story. Some of you have heard it before. I encourage you still to laugh at the end. So I do my law degree and I move to London. I start my training as a lawyer, and on a blind date, I'm met by a very handsome gentleman in Soho. We get to talking about our jobs. What do you do? He says. I'm a lawyer, I say. What sort of lawyer? He asks. An environmental lawyer. He smiles. Oh wow, you get to save the whales. There was then a long and awkward pause. Actually, I said, I act for BP and BAE Systems. I'm on what you might think of as the whale killing side of the profession. The date ended pretty quickly after that. Today, important questions are being asked by Adrian Evans, by Viv Holmes, Amy Salazan, by myself as a form of therapy. Questions about the role of law firms as professional enablers of climate change. The work that the clients of those firms do is legal, but it has significant environmental impacts, lawful but awful, to borrow a phrase. Take a different example that Richard Moorhead and I have written about. You are an employment lawyer. Your client asks you to draft a non-disclosure agreement for their CEO connected to allegations of sexual misconduct. A year later, another NDA. 2 years later, a third, and then a fourth. At what point do you ask the hard questions? At what point do you stand back and say no more, even though the thing you are asked to do is, on one reading, probably legal? At what point do you permit yourself to accept that you are not just defending your client's rights, but you are instead enabling their alleged sexual crimes? Then we have robo-debt. From 2016 to 2019, the Australian government raised more than 500,000 unlawful centre-linked debts using a process called income averaging. These debts were often incorrect. People were told to prove they didn't owe money, to produce pay slips from years ago, or to face debt collectors. This scheme caused immense psychological harm. What role did lawyers play? Well, in-house lawyers in the teams of the Department of Human Services, the Department of Social Services, failed to act independently. The Royal Commission said that those teams did not display, quote, a professional ethos. They didn't recognize their duties as lawyers. They didn't report known flaws. They didn't challenge policy positions. They were siloed. They were mouthpieces instead of gatekeepers. Those failures hurt real people. Take Crown Casino. A Royal Commission found that for over a decade, Crown facilitated money laundering, underpaid taxes, helped wealthy patrons move money overseas, illegally ruined the lives of many vulnerable gamblers, and put employees at risk of imprisonment. Crown's in-house lawyers were intimately implicated in these matters, including in preparing legal arguments in anticipation of potential scrutiny from a regulator for actions that were likely illegal. Instead of saying this is improper, those lawyers advised how to cover the tracks. A third example from the UK in the Post Office. Between 1999 and 2013, hundreds of sub-postmasters were accused of fraud, theft, false accounting, based on faulty data from an IT system called Horizon. That system routinely produced accounting errors. Instead of investigating the IT, the Post Office started prosecutions, over 900 in total. Many postmasters lost their jobs, their homes, their reputations. Some were jailed, others took their own lives. Lawyers inside and outside the Post Office helped to prosecute. They advised on settlements, they drafted non-disclosure agreements, they failed to disclose material errors, they crushed dissent, they hid flaws, they punished the innocent. What links these examples is not just the wrongdoing, but the pattern. In each example, lawyers were in the room when it happened. They were not rogue actors, they were professionals, respected, credentialed, and embedded in very powerful institutions. They did not say no, or they said it very quietly, or far too late. So the public rightly asks, who do lawyers really serve? Do we serve justice, or simply whoever pays us? Do we speak truth to power, or do we simply help power to write its own script? Do we help to protect rights, or suppress them behind contracts and clauses and closed doors? If we want the public to trust us, we have to answer those questions with, and that's the whole point of my lecture, with a daily practice of independence, integrity, and of moral courage. Next, I want us to think about how lawyers might reclaim our role, not just as client advocates, but as living agents of the rule of law, as people who in flawed systems and as flawed humans can try our very best to choose to act with independence and integrity. I spent many years researching lawyers. If there is a single theme across all of my work, it is that lawyers forget or downplay the agency they have and the responsibilities that they have. So what is that point of lawyers? Well, at our very best, lawyers can and should and do serve something and embody something bigger than clients. Let me use a word that has lost some of its force in recent years: professionalism. At its core, we link this idea of professionalism to a few key themes. Professionals are seen as experts, they hold deep specialized knowledge, they have a form of social license, the authority to practice, to decide who can join their ranks. They have ethical codes, the power to discipline. Perhaps most importantly, there is a public promise that is built into professionalism. Professionals are supposed to exercise their knowledge not just for personal gain, not just for client service, but also for the benefit of society. They are trusted to act in the public interest, even when it's very hard. Keep this in mind as we turn to the rule of law. At its heart, the rule of law is a concept that says law should govern us, not whim, that no one is above the law, that law should be predictable, public, and fair. And we argue about the rule of law because we argue over what good societies look like, what things are important or necessary for democracy. And lawyers are a huge part of how the rule of law gets done. In that way, the rule of law is about its agents, about the people who give it life, as much as it is about text and institutions. It is too tempting to think about the rule of law as text and structure, parliaments, courts, statutes, etc. But text and institutions do not function on their own. They need interpretation, they need action, they need judgment. The rule of law depends on that work. It depends on lawyers as its products, servants, and agents. In America, the American Bar Association's model rules open with this sentence: a lawyer is a representative of clients, an officer of the legal system, a public citizen having a special responsibility for the quality of justice. If lawyers are to be the guardians of the rule of law, if we are to have that special responsibility for the quality of justice, we must do more than simply follow instruction. We must advise and counsel, we must challenge, we must warn, we must sometimes walk away. And that view of lawyers as having that special responsibility for the quality of justice depends on those inside the profession upholding the rule of law with conviction and with principle. And that brings us to a fundamental responsibility of lawyers, the duty of integrity. As Dean, I have, on very rare occasion, come across behavior that I do not like and I find troubling. And when I see that behavior, I'm known for sending an email to the faculty that has a simple core message: do better. Behind that email is a sense of disappointment that I expected more because of the people I am addressing. That really is what we're talking about when we come to this complex and contested thing we call integrity, a principle that is often framed as a duty in many codes of lawyers, Australia, the UK, and elsewhere. Integrity gets to the heart of what it means to be a solicitor. In Wingate and Evans, Lord Justice Jackson said, "In professional codes of conduct, the term integrity is a useful shorthand to express the higher standards which society expects from professional persons and which the professions expect from their own members. The underlying rationale is that professions have a privileged and trusted role in society. In return, they are required to live up to their own professional standards." So we have this sense that something more is expected of lawyers because of that professional requirement of integrity. Higher standards, do better. Most who write about integrity agree that acting with it will be pretty hard sometimes. Deborah Rhodey, for example, has commented that persons of integrity are individuals whose practices are consistent with their principles, even in the face of strong countervailing pressures. Put another way, what we're looking for when we ask lawyers, when they have that legal obligation to act with integrity, is that they show a bit of moral courage. Take an example that Richard Kentasuda and I have written about. This is Ben Horowitz. He is a prominent US tech CEO, and Horowitz credits his chief in-house lawyer, General Counsel Jordan Breslow, with keeping him out of jail. So at one point, the firm's CFO suggested a legally questionable stock option structure. The outside lawyers, the third-party lawyers, said it was fine, it could work. Competitors were doing it. Nothing screamed illegal. But Breslow, the in-house lawyer, took a deeper look. He had a gut feeling and he said, no, let's not do this. Years later, the same structure was investigated, it was prosecuted, people went to jail, and Horowitz, the CEO, says the refusal of his general counsel, based not on regulation but on instinct and discomfort, kept him as CEO out of jail. That is what integrity looks like in practice, not a billboard slogan, a lawyer quietly asking, is this right? Is it honest? Does it follow not just the letter, but the purpose and the spirit of the law, showing moral courage? And this concept brings us back to the promise of and the need for professional independence. Professional independence has long been seen as the hallmark of what it means to be a lawyer, a foundation of trust that ensures that lawyers act with integrity, competence, detachment. In theory, professional independence shields lawyers from undue influence from clients, market, and the state. And at its best, what professional independence should do is to allow lawyers not just to serve their clients, but also that broader public interest. In practice, however, things are more complicated. In research that Emma Oakley and I did, most lawyers we interviewed that professional independence was important, but few could define it. Some said they'd never heard of it before. We didn't find among our interviewees any examples of that classic liberal ideal, lawyers offering cool, dispassionate, reflective judgment. Instead, many told us that their jobs had shifted from trusted advisor to hired gun. And that balance of power, especially in large corporate law firms, has tilted over time in favor of a client. One interviewee said to us, most law firms were hired hands, were instructed to do things, and if your client says, I want you to go in there and be a poodle, you go and be a poodle. And if they say, I want you to go in there and rip these guys to pieces, that's what you try and do. Now, this poodle problem reflects more than just colourful language. It reveals a deeper erosion of professional independence. And many lawyers we interviewed said that client relationships are now simply commercial service contracts. When lawyers begin to see themselves as mere facilitators, rather than advisors whose primary concern should be the quality of justice, independence becomes a myth. And it has real-world consequences. We saw it in robo-debt, those lawyers whose independence was compromised. We can also think about the US, the 9 US law firms who have agreed to provide pro bono legal advice valued up to $125 million to avoid sanctions by the Trump administration. A recent position paper on this by the German Bar Association has said that, quote, these deals may cast doubt on the independence of those firms from the government because those firms are seen as nothing more than a hired mouthpiece. In practice, professional independence is meant to look like reflection, responsibility, and a willingness to say no. And if lawyers can't do that because they're too close to client demands or political priorities, then the entire legal system becomes more fragile. Independence helps shore up trust in the profession. It is what helps make manifest that idea of lawyers as living agents of the rule of law, not just servants of their clients. So let's look a bit more depth at those living agents and what that means. Here I'll draw on some work that Richard Kenter and I did for the Legal Services Board, the apex regulator. So lawyers are integral to the social architecture that sustains the rule of law. They actively reinforce legal norms. They provide the scaffolding for trust in law and legal institutions. The Crown Casino Commissioner, Monash Law alum Ray Finkelstein said, the lawyer is part of the system charged with upholding the law. And behind this is that really important idea. The law is not self-executing. It depends on the actions of legal professionals who shape, interpret it, and apply it across millions of decisions, many of those moments of decision hidden away from public or third-party scrutiny. Second, lawyers as living agents of the rule of law play a vital role in protecting citizens from arbitrary power and ensuring that state authority remains within legal bounds. Lawyers need to be independent to do this, not just their clients, but also from the state. Third, a central function of lawyers is to guide clients towards legality through the legal landscape helping individuals, businesses, governments to act within the bounds of the law. Now, let me ask you a question. Do you think it is your job as a lawyer to use uncertainty in the law for your client's advantage? Now, normally I would ask for a show of hands, but I won't given the audience tonight. And the reason for not doing that is because the single strongest predictor, statistically, of a poor ethical inclination is how you answer that question. If you think it is your job to use uncertainty in the law to your client's advantage, we have shown in the work that Richard, Christina Godino and I did in the world's largest study of in-house lawyers that you do very poorly on the standard ethical tests. Legal counseling is not value neutral. Lawyers interpret rules that are often ambiguous or conflicting, duck or rabbit, and a lawyer's advice can either support integrity or undermine it. Fourth, a lawyer's duty to the rule of law as its leading agent includes facilitating access to justice. When lawyers act to frustrate opponents' ability to have their claims heard through procedural tactics, resource-based intimidation, they undermine justice. We see this in lawfare and with slaps, in which legal tools are used to exhaust or silence weaker parties. Fifth, and this is really important, lawyers do not just serve the rule of law in court. The daily work of drafting, negotiating, advising, of structuring transactions, all of those things shape how the law is understood and applied, and often that private legal work has public consequences as significant as any court decision. And so when lawyers operate behind closed doors without third-party oversight, their responsibility to uphold the law is heightened. So those things I've been talking about, those needs to be independent, to advise with purpose, to challenge power, to avoid complicity, to refuse to mislead, to act with integrity. They are not theoretical aspirations, they are professional obligations. They are also duties that were absent in the scandals I spoke about earlier. In Robodebt, lawyers let themselves become bureaucrats. They lost their professional ethos. In Crown, lawyers enabled deception. They saw the field as a game. In the Post Office, lawyers drafted agreements to silence the truth. They used the courts in ways that threatened the administration of justice. And in Lawyer X, the legal system betrayed itself. When we abandon independence and integrity, we don't just harm our clients. We erode the foundations of public trust in law, in the rule of law, in the administration of justice. Before I draw this to a close, let me talk a bit about people, what we might frame as the practical challenge of role morality, of people still being people even when they are lawyers. And let me do this by telling a couple more stories and asking you some questions. So I was at Freshfields for my training. When it came to qualification, I had to decide, would I be a real estate lawyer? Would I be an environmental lawyer? I like both, but I wanted really to be an environmental lawyer. There was, however, a problem. I didn't mind acting for BP and BAE Systems in the environment team, but that team also did work for a large tobacco client. And my mother had died when I was 9 from smoking, and I just couldn't do that work. So I spoke to the partners and I said, look, I'd love to join the environment team, but I can't act for the tobacco client. And they said, fine, come and work for us. You don't have to act for that client. We'll give you other work to do. That's what happened. Over time, the partners would ask, have you perhaps changed your mind? This is legally innovative and interesting work. Maybe you'd now like to do it. They weren't being pushy. It wasn't inappropriate. But I just didn't want to stay in that team and even be part of that world. And so I left, and I went to work for Latham & Watkins. Here's my question. In that story, do you think that I acted with integrity? I suggest you can tell the story in at least 2 ways. The first telling says that I acted with moral courage on a personal level, both in raising with the partner my discomfort and then leaving when things got too much. That I stayed true to what mattered to me as an individual. In the second telling, the same story might be told that my professional integrity was compromised. In choosing to work at Freshfields, I'd already impliedly agreed to act for any client that the law firm chose, that the work would be legal. In not working for tobacco and going to another law firm, in that second telling, I was putting my own personal values ahead of my professional commitments. More human, less lawyer, more human, less agent of the rule of law. Years later, one of the last big deals I did at Latham was the sale of Harrods, where Latham acted for the Qatari royal family. We did the deal, I moved on. I never really thought about the purchase of Harrods or the work that I did for the Qatari Investment Authority, which was kind of funny because I'd also set up the LGBT group of the London Latham office, and because I knew, because who doesn't know, of the physical and other persecution of queer people in Qatar, the lack of rights there for people like me. Is it not a bit hypocritical that I left one law firm because of one set of moral views, but didn't act in a second situation in a way that aligned with one important aspect of my identity? And in my research, I call these very personal preferences and red lines examples of meatloaf lawyering. I'll do anything for my clients, but I won't do that. If you laughed or didn't laugh, it's either because you enjoyed or didn't enjoy the joke, or it's a function of your age. I'm grateful for those of you who did make the effort. In those stories I just told you, for complex human reasons, my mother's death had greater purchase than my sexuality. And each of us has those red lines. Each of us has things we will and won't do. Each of us has our meatloaf lawyering examples. They're often not shaped by universal ethics, but by personal histories, relationships, and other things. Why tell you those stories? Well, despite the fact that my central argument from tonight is that lawyers are these living agents of the rule of law, lawyers are still human. And asking for moral courage from them and of them, of us, is hard because we are human. We will sometimes make mistakes. We will carry contradictions. We will tell ourselves stories to justify our work. We will draw red lines and sometimes cross them. We will get things wrong. We all have blind spots. We all do work that, in hindsight, we regret. That does not make us imposters. It simply makes us human. It also doesn't mean we shouldn't set very high standards, but merely that we should accept some examples of failure. What matters most is that lawyers stay in that habit of reflection, of asking hard questions, of choosing integrity when it costs something, not when it is easy. In living this life of professional integrity, in acting with independence, in being those living agents of the rule of law, what we require in the exercise of moral courage is some form of moral imagination on the part of lawyers. The ability to see beyond the immediate and our clients, to understand the consequences of our choices, to understand our special place in society. So when a lawyer drafts a non-disclosure agreement that silences a whistleblower, they're not just writing a contractual clause, they are possibly closing a door on accountability. When a lawyer advises a client to delay discovery, they're not just being strategic, they are risking the obstruction of justice. When a lawyer structures a deal to hide ownership or avoid regulation, they're not just minimizing risk, they are actively shaping how power operates and fields of winners and losers. Lawyers are socially necessary, not because we are perfect, not because we should be expected to be perfect, but because the law is not automatic. Rules don't enforce themselves, the law is not self-executing, because justice needs interpreters and defenders and challengers, explainers and guardians. Because the rule of law is just as much about people as it is about text and institutions, because lawyers are those living agents, those norm intermediaries of the rule of law. And so when lawyers choose to act with independence and with integrity, when lawyers choose to show moral courage even when it's hard, we become something more than service providers. We become stewards and agents of the rule of law, actively working to improve the quality of justice. And that, I think, is the point of lawyers. Thank you very much.
Thank you, Steven. You know me well enough to know that it's very hard to silence me, but you have done that. I'm sure all of us are thinking now about our red lines and thinking afresh about what moral courage looks like as lawyers, and for those of you who are not lawyers as well. I feel incredibly encouraged that the future of the profession in Victoria is in very good hands while you are the Dean of Monash, and it's a privilege to have you here and to have heard from you tonight. Please join me in thanking Professor Vaughan. We've now got an opportunity to enjoy some hospitality from Monash, so please do exit through the doors which are being opened and continue the conversations over some refreshments. Thank you.